Welcome to the deep dive. Today we're digging into a story that really got a lot of public attention. It's about a delivery rider, the Jita, whose court case kind of blew up.
It really did. And the headlines, they focused on this big struggle for bail.
Exactly. So our mission today is to cut through all that noise. We're going to use the official judicial record to see how the system actually works, especially when it comes to protecting rights and, the whole process of getting released.
That's the key, because when a story like this gets so much play, the narrative can get a little too simple, right? It becomes good guy versus the tough court.
And we want to peel that back.
We do. Our whole discussion today is based on the official clarification that came out from the judiciary spokesperson, Mr. Suryan Hongwillai. That was back in early November of 2025.
And that statement, it wasn't just the court being defensive, was it?
Not at all. It was really about them laying out their modern policy on what they call provisional release.
And that's the real gold mine of knowledge for you, our listener. We're going to trace the timeline of this one specific case to show a huge policy shift. This move away from just relying on cash bail, we're looking for those facts the headlines missed.
Okay, so let's unpack it.
Yeah, let's start with the charges. How serious was this? What did the public prosecutor in Chiang Rai actually file?
Well, the initial filing was on October 27th, 2025. And, this wasn't some minor thing. The prosecutor filed charges against two people.
Two people.
Yep. Defendant 1, who was identified as Mr. War, and then Defendant 2, Mr. Poor, and he's the writer we're focusing on.
And what were they accused of? I mean, the crime itself really dictates how the court is going to approach it.
For sure. They were facing a pretty complex set of serious joint charges.
Like what?
3 things. Joint forgery of official documents, joint use of those forged documents, and receipt of stolen property.
Wow, okay, so those are heavy charges.
They are, and that brought them straight to the Chiang Rai Provincial Court.
So it's October 27th. They're both in the courtroom facing this really heavy slate of allegations. What's the very first thing the court does? What's its absolute top priority?
Rights protection. Specifically, legal representation.
Before anything else?
Before anything else. The court immediately asked them if they had lawyers. Defendant 1 said he'd find his own.
Okay, but what about the writer? Defendant 2?
He said he needed help. He requested the court appoint a lawyer for him.
And what was the response to that? Was there, a delay, paperwork?
None. This is a really critical point that shows you the policy in action. The court instantly issued a letter requesting legal aid for the writer.
So that rights protection policy, it just kicked in immediately.
Right away. And then they scheduled the next big step, the plea taking and the rest of the rights protection process, for November 13th.
What really stands out there is that the whole system for legal defense was instant. It was effective, and it was provided for the more vulnerable defendant right from the get-go.
It was. But this is also where the timeline starts to get a bit confusing for people who were following the story.
How so?
Because right after that initial question about lawyers, the court had to make that crucial decision about pretrial freedom.
The bail question.
Exactly. The court ordered the detention or remand of both defendants unless they could secure provisional release.
Okay, and this is where it gets really, really interesting. Because the two defendants who are standing there side by side, they took completely different paths.
Completely different, and those paths determine whether they walked free that day or not.
So let's look at Defendant 1 first. What did he do?
Defendant 1, he went the traditional route. He immediately filed a request for provisional release.
And he had the money.
He had cash collateral, specifically 50,000 baht. He submitted it, the procedure was followed, and the court granted his release that same day, October 27th.
Clean, standard, and fast.
Yep.
Now let's compare that to the writer, Defendant 2. This is the crucial part of the story, the piece that the public narrative really missed.
It is. The official source is crystal clear on this. Defendant 2, the writer. He did not file a request for provisional release at that time.
He didn't file at all.
Not at that moment.
What?
And this is the part we really need to emphasize. He also did not ask for any of the other options available, like using an electronic monitoring device, an EM tag, instead of cash.
Wait a minute. So you're telling me the reason he was detained wasn't because the court looked at his case and said, nope, too risky, bail denied?
That's not what happened.
His detention was procedural.
Yeah?
It was just because he hadn't filled out the right form or asked for the other options that were sitting right there waiting for him.
That is the factual nugget right there. That's what we need to pull from this source material. The court had the mechanism in place. The official clarification even says they had enough EM devices ready to be installed if he'd just asked.
So his initial 2 days in detention were because of a lack of application, not a rejection by the court.
Exactly. A lack of application.
That completely changes the conversation. It shifts it from being about judicial bias to being about, well, procedural awareness, doesn't it?
It does. It highlights a huge gap. The policy is there, the hardware is there,
Right.
but the user, in this case, the defendant, has to know to ask for it.
Why do you think that step was missed? Right there in the courtroom on the 27th.
Well, I mean, it raises a big question about stress
Right.
and comprehension and just how much advice you can get in those first few moments.
Sure.
The court assigned him a lawyer, but the writer might not have fully processed all the options. Or maybe he just assumed, I don't have 50,000 baht in cash, so that's it for me. Release is impossible.
Which is the old way of thinking.
It is. And the whole point of this new judicial push is to show that cash is no longer the only thing that matters.
Absolutely. The court was ready to use non-monetary alternatives.
Yeah.
But if he didn't know to ask for the EM device, the default position was detention. So what finally got him out? It wasn't him suddenly finding 50,000 baht.
Right. No, it wasn't. 2 days later, on October 29th, an outside party stepped in. And this detail tells you a lot about the modern ways you can secure release.
An external party. Who was it?
It was Viraya Insurance Public Company Limited.
Insurance company.
Yes, they filed for something called Freedom Insurance, or
Freedom Insurance. What is that?
It's a mechanism where the insurance company basically guarantees the 50,000 baht collateral for the defendant. It serves as a non-cash guarantee from a credible third-party institution.
That is fascinating. So it's a way for a third party to provide financial backing to jump that collateral hurdle without the defendant needing cash on hand.
Precisely.
So once that Freedom Insurance guarantee was filed on the 29th, did the court move quickly?
Instantly. The court granted the provisional release based on that insurance guarantee and issued the release warrant that same day.
So the system was responsive. It just needed the right application and the right kind of security, whether that's cash or an EM request or this insurance.
The system worked. It just needed to be activated.
So the story here is less about a court failing to grant bail and more about all these different paths that are now available to secure release and the fact that you have to know those paths exist.
Yes, and that brings us to the bigger policy picture that the judiciary spokesperson really wanted to get across.
Right. Why did the judiciary feel it was so important to publish such a detailed breakdown of this one specific case?
Because this case was the perfect illustration of both the success of the system and the challenge that still remains.
What's the success part?
The success is this continuous policy to protect rights and expand the opportunities for provisional release. The goal is to make sure detention isn't the default while you're waiting for trial. They're actively trying to make sure that how much money you have isn't the only thing that determines your liberty.
And the institutional commitment to that policy sounds pretty intense from what the source says about court accessibility.
It is, and this is so important for you, the listener, to grasp. The spokesperson made a point of saying that courts all over the country operate every single day, no holidays, specifically to handle these release requests.
Wow, every day.
That level of access shows you that getting people released when appropriate is a central part of their policy.
That's a huge institutional effort behind the principle of liberty.
Yeah.
But, okay, for most people facing charges, the practical question is still, if I don't have 50,000 baht, what are the actual tangible alternatives the court will use instead of money?
So the official source details two key non-monetary alternatives. It shows a real shift towards accountability measures instead of just financial ones.
Okay, what's the first one?
The first is appointing a supervisor for the person who's released. Someone who reports on them and is responsible for making sure they comply with the rules.
So that moves the focus from financial assets to social accountability. What about the second one, the more tech-focused one, the one the writer could have asked for right away?
That's the electronic monitoring device, the EM tag. It lets the court track or restrict a defendant's movement, which ensures they follow the release conditions and don't flee, all without them having to put up any physical collateral.
If we connect this to the bigger picture, this is a really profound structural shift, isn't it? I mean, historically, pretrial freedom was almost always bought with assets. It made the system inherently unequal.
Exactly. A poor defendant stayed in jail. A rich one walked free.
So the source is basically broadcasting a message.
It is. It's saying the judicial process is evolving to close that equity gap. The entire purpose of these new measures is to make sure that having no money, no superintendent or assets is no longer the thing that stops you from getting provisional release. You can still file a request to use supervision or an EM device.
But the writer's experience shows this fundamental disconnect. The court had the devices, the policy was there, a lawyer was assigned, and yet he still sat in detention for 2 days because he didn't start the process to use these non-monetary options.
That's where the policy implementation stumbles.
It highlights the difference between policy availability and public awareness.
It does. The policy aims for universal access, but the procedural knowledge you need to actually activate that access isn't universal. Defendant 1 knew the old system cash, and he got out instantly. Defendant 2, he either didn't know about the new system, the EM tag request, or he didn't feel empowered to ask for it.
Which led to the delay until that outside group stepped in with the insurance guarantee.
Right. So the system is designed to grant freedom where it can, but the burden of activating the specific mechanism, especially the modern non-monetary one, it still falls on the defendant.
So the spokesperson's clarification is basically a public service announcement. It's trying to bridge that knowledge gap.
Absolutely. They're telling defense lawyers, defendants, families that they need to proactively ask for the EM or for supervision right away instead of just assuming that traditional cash bail is the only way.
That detail on the freedom insurance is also really insightful. It shows the private sector is also finding ways to bridge that collateral gap.
And it proves the court accepts these new forms of security. I mean, the court's main goal isn't just to hold 50,000 baht in cash.
Right.
It's to have a credible guarantee that the defendant will show up for trial. Whether that guarantee is cash, an EM tag, or an insurance policy, the objective is the same.
Okay, let's wrap up the key takeaways here for our listener. The most surprising facts we've pulled out are, first, the writer's initial detention was procedural, not prohibitive. It happened because of a lack of an application for alternatives, like the EM tag, which was available.
Second, we saw the efficiency of the legal aid system. Counsel was provided immediately. And third, we got a detailed look at these alternative measures, EM tags, supervision, and that innovative freedom insurance, which all show there are multiple ways to get released without personal assets.
So when we zoom out, what does this all mean? This detailed summary highlights the legal system's commitment not just to justice, but to procedural equity. They've tried to remove the wealth barrier.
But the gap that's left is the knowledge barrier.
Exactly.
The policy is forward-thinking. It's committed to expanding freedom, but its effectiveness is just severely limited if the defendant doesn't know to ask for the options that don't require cash.
Which brings us to a final provocative thought for you, the listener, to think about. Given that this procedural knowledge can literally be the difference between detention and freedom for someone without money, what specific proactive role should our public institutions, the courts themselves, the police at the time of arrest, maybe legal aid groups, play in making sure that vulnerable people are immediately and systematically told about alternatives like electronic monitoring before they're left alone to decide whether to even file for release?
Because that procedural knowledge, that's the next frontier for ensuring true equity and provisional release.
Until the next deep dive, stay curious.